Good evening, everyone. Today we'll be talking about the third part of the Mediation Act, wherein we'll be dealing with Mediated Settlement Agreement, online mediation, and the Mediation Council of India. So let's start with the concept of Mediated Settlement Agreements. So, what is a Mediated Settlement Agreement? A mediated settlement agreement is a legally binding document authenticated by a mediator and signed by both the parties. So all these three are the essentials of a mediated settlement agreement. That is, a legally binding document which has the force of law, authenticated by the mediator, and it is signed by both the parties. Now, what are the effects of this settlement agreement? First is that it is a final and binding agreement. It is binding on both the parties. And second, it is enforceable under the law under the provisions of the Civil Procedure Code 1908, which means that it can be treated like a judgment or a decree passed by the court. So, what are the effects? First is that it would be a binding agreement on the parties. It is a final and binding agreement on both the parties. And secondly, it has the same effect as a judgment or a decree of the court that has been passed by the court as per the CPC. Now, it can also be used in legal proceedings. In which way? In the form of a defense, set off, or any other legal proceedings. So, when we talk about mediated settlement agreements, it can be used in the court for the purpose of defense, set off, and any other legal proceeding. Now, can a mediated settlement agreement be challenged? Yes, the parties to the mediation can challenge the mediated settlement agreement. The procedure would involve filing an application in the competent court or tribunal. Now, there are certain grounds for the challenge of a mediated settlement agreement which have been laid down in section 28 clause 2, which specifies that these grounds are fraud, corruption, impersonation, mediation in disputes not fit under section 6. Now, as the name itself suggests, that these situations particularly become the ground for the challenge of a mediated settlement agreement, which include fraud, corruption, impersonation, and disputes which are not fit to be settled by mediation under section 6. If they are mediated, then again it becomes a ground for the challenge. Now, the time duration, the time limit for which the challenge period exists, has been specified in section 28 clause 3, which states that a mediated settlement agreement can be challenged within a period of 90 days from the receipt of the agreement copy. Now, is this an extendable period? Yes, it can be extended up to an additional period of 90 days if the court is satisfied with the reason of the delay. Again, we have to keep this into mind that it can be only extended if the court is satisfied that there is a reason for the extension that exists. There's a reason for the delay. Now, we'll be talking about the concept of online mediation, which has been discussed in chapter 7. What is online mediation? Online mediation allows the parties in a dispute to resolve their issues virtually using electronic communication tools. So, online mediation is mediation, as the name suggests, it's mediation done online. So, it is done with the help of the electronic communication tools. Again, the concept of mediation remains the same. The aim is to resolve the dispute between the parties, but the medium for resolving the dispute changes to an online platform, wherein electronic communication is used to resolve the disputes. Secondly, this can include written consent forms, encrypted emails, secure chat rooms, video conferencing, or audio conferencing. So all these can be a part of online mediation. It can be it can happen through all these channels, which include written consent forms, encrypted emails, secure chat rooms, video conferencing, audio conferencing. Now, stages. Online mediation can be used for both pre-litigation as well as ongoing dispute. So there's no restriction at which stage can we start an online mediation. It can be there at a pre-litigation stage as well as for any ongoing dispute. Conducting online mediation. The process for online mediation will be further specified in official regulations. Now there will be official regulations which would be notified by the central government, wherein we'll get more details on how online mediation would function in future. The core principles, however, will remain the same, which include that the mediator must ensure the integrity of the proceedings. The mediator has a responsibility, like any other mediation which happens in physical form as well. The mediator has the responsibility to maintain the integrity of the proceedings. That shouldn't be compromised. Secondly, the responsibility of the mediator is to maintain confidentiality. Now, mediation is a very confidential procedure. So, the mediator in online mediation also has the same responsibilities. This may involve using secure communication platforms and taking appropriate steps to prevent unauthorized access. Now, when we talk about confidentiality in online platform, there's an extra layer of confidentiality that has to be taken care of by the mediator. This can be done by taking secure communication channels or undertaking those channels for enabling communication between the parties and the mediator, and to take appropriate steps to prevent any unauthorized access. The person who does not have access should not be able to see the chats or talk to the mediator in any way whatsoever. Now, when we talk about confidentiality in online mediation, so confidentiality is the cornerstone of successful mediation, both online and in person. Confidentiality is one of the key principles of mediation. So, be it online mediation or be it an in-person mediation, confidentiality is a must to have a successful mediation process in place. The Act emphasizes that all communication during online mediation must be confidential. That has also been specifically stated in the provision. This means that the information disclosed during the mediation cannot be used in subsequent court proceedings without the consent of the parties. Now, during online mediation, the communication that is done is very confidential, and that communication cannot be used in any subsequent court proceedings without the consent of the parties. Now, when we look at the advantages of online mediation, first is convenience, participate from anywhere. So, online mediation is a very convenient tool, especially when the technology has gone so advanced, and people now, even the courts these days, we have the provision of virtual hearings. So similarly, when we talk about online mediation, it is very much convenient to the parties. They can participate from anywhere and their physical presence is not required. Secondly, it's effective. Now, cost effective because it reduces the travel cost of the parties to travel to a particular place, since the mediation takes place online, and the cost of the venue where the mediation takes place. For example, if a mediation is an in-person mediation, so the cost of the venue is also saved in online mediation. Thirdly, accessibilities for parties with disabilities or in remote areas. So now when the parties live in any remote area or they are unable to come to a venue fixed for mediation, accessibility is one such issue that has been sorted by online mediation. The parties can literally attend the mediation proceedings from anywhere. It is time efficient because it is easy to schedule. A person does not have to travel or does not have to arrange for or accommodate for a lot of time and space. That way, it is very time efficient because the scheduling becomes easy and the party can attend the mediation proceedings online. It is also eco-friendly because of the reduced carbon footprint. Now, in online mediation, we use chat rooms or we use secure video conferencing or audio conferencing. In that manner, it becomes eco-friendly since there is no paper trail involved. Challenges and considerations. Now, online mediation also faces its set of challenges. One is the digital divide, that is the access to tech. Now, everyone does not have access to technology. This is where online mediation poses a problem because there exists a digital divide wherein some people are able to access online services, they are able to get online and conduct the mediation proceedings, whereas others might not be able to because of the fact that they are not tech savvy or they are not very much tech friendly. Secondly is privacy concerns, data security. Now, privacy concerns is a very important factor when we talk about the challenges of online mediation. When we talk about the privacy of the participants, the privacy of the disputing parties, as we've already discussed, mediation is a very confidential process. So, in case the privacy of the party is breached, the entire confidentiality that should exist in a mediation proceeding, that also becomes of no use because when there's no privacy, there's no confidentiality. Third, non-verbal cues may be harder to understand. Now, when we talk, for example, the online mediation takes place through chatting platforms, secure chat rooms. Now, when we talk to each other verbally, we are able to understand the body language. We are able to catch the verbal cues. Whereas when we are in an online chat room, there is no verbal element involved. It can be much harder to process the language, uh, the meaning, the essence of what the party is trying to say. Fourthly, technical issues, which include internet or power shortages. Now, even if the party has an internet service, there is a possibility that there comes a time where there are some technical issues. Maybe the electricity runs out, the internet accessibility is not proper. In that case, again, the process gets hindered because the proceedings are stopped or they are not able to smoothly communicate in one go. That is how it poses a problem. Fifthly, training. The mediators need tech skills. Now, not only the parties, the mediators also need to be technologically friendly. For this, mediators need to be given some online training in order to make sure that the mediator is tech friendly, is aware of the technical skills, and is able to conduct the mediation proceedings smoothly. Now we'll be talking about the Mediation Council of India. Firstly, we'll talk about the establishment and incorporation of the Mediation Council. Now it will be established by the central government notification, as in when the central government notifies. The Mediation Council of India is basically a body corporate with perpetual succession and common seal. So it is a body corporate, it has perpetual succession, and it has a common seal. The powers of the Mediation Council include that it can acquire, hold, dispose of property, be it movable or immovable. So it has all the three powers: acquiring property, holding property, and disposing of property, whether it's movable or immovable. Secondly, it can enter into contracts. And thirdly, it can sue and it can be sued. Now, the head office of the Mediation Council would be in Delhi, or if any other place is notified by the government. It can establish offices in India and abroad. This has to be in consultation with the central government. Now, when we talk about the composition of the Mediation Council, there exists a chairperson who is appointed by the central government. This person this is the person of ability, integrity, standing knowledge, experience in law, ADR, mediation, public affairs, or administration. Now, there are two members who are again appointed by the central government. One of them has to have some experience in mediation or ADR laws, and second is an eminent person in research, teaching of mediation or ADR laws. Now, the ex officio members include the secretary of the Department of Legal Affairs or representative above the rank of joint secretary, the secretary, Department of Expenditure or representative, joint secretary or the above rank, the chief executive officer would be a one part-time member who's a representative of recognized commerce or industry body. Now the tenure would be for 4 years and they are eligible for reappointment. When we talk about the age limit for the chairperson is prescribed as 70 years, whereas for other members it is up to 67 years. Salaries and allowances would also be as per the prescribed amount. Now, another aspect that we have to take care of is that the vacancies or the defect does not invalidate the proceedings. A vacancy or a defect in the council's constitution would itself not invalidate the proceedings. The defect in the appointment of a member would not itself invalidate the proceedings, and any irregularity in the procedure which does not affect the merits of the case would also not invalidate the proceedings. Now, when we talk about resignation, it can be by notice in writing to the central government and it will continue till earliest of 3 months from notice. The person has to continue up till 3 months of notice period or when the successor is appointed or when the term expires. Now, we will also talk about the removal by the central government. A person can be removed from the mediation council if he or she is an undischarged insolvent, has paid employment without permission, conviction involving moral turpitude, prejudicial financial or other interests, abuse of position against public interest, physical or mental incapacity, an opportunity of being heard has to be given. Now, on these grounds, the central government can remove the member from the Mediation Council of India. These grounds include if the person has been undischarged insolvent, or he has a paid employment without the permission, or he has committed a crime of moral turpitude, or there exists a prejudicial financial or other interest, or where there is an abuse of the position against the public interest. Also, the ground for mental and physical incapacity also exists. Now, when we talk about the duties and the functions of the Mediation Council, these include promote domestic and international mediation in India. Second, develop India as a robust mediation center. Third, guidelines for education, certification and assessment of mediators. Fourth, provide manner of conduct of mediation proceedings. Fifth, registration of mediators, which also includes the renewal, withdrawal, suspension or cancellation of any mediator. Next, it lays down standards for professional and ethical conduct of mediators. Next is conduct trainings, workshops, courses, and collaborate with the stakeholders in that regard. Next is enter into MOUs or agreements with domestic and international bodies. Next is recognize mediation institutes and service providers. Next is specify criteria for recognition of institutes and service providers. Next would be call for information / records from institutes and service providers. Next is lay down standards for institutes and service providers. Next is publish information, data, and research studies. Next is maintain electronic depository of mediated settlement agreements. Next is perform other functions as assigned by the central government. So in all these points, we have seen the specific functions of the Mediation Council of India that have been specified in the Act. And lastly, it also says that it can perform any other function as prescribed or as assigned by the central government. So as we can read from the duties and functions, that all these functions or the duties of the Mediation Council make it a very, very important body. It helps in the registration of the mediators when we talk about the renewal, withdrawal, or the suspension of any mediator. Then also the mediation council plays an important role. It helps in developing, it fosters the environment of mediation in the country. It helps to develop, its aim is to develop India as a robust mediation center. It also has been given the responsibility of conducting trainings, workshops, and courses along with others, along with the collaboration with other stakeholders. This is all for today. Thank you.